On this video, we're going to navigate the probate court in an easy step-by-step guide, and we're getting after it right now. And I'm Mike Gallagher, and if you want to learn everything about the Utah probate process, you've come to the right channel. I'm a realtor located in the state of Utah that specializes in selling probate homes. So if I can be of any assistance, give me a call, shoot me a text, send me an email. We got your back when selling a probate home. Step number one, I'm going to call this one to open probate. So an executor can't jump right in and start passing along family heirlooms and inheritances. No one can say, here, you get the car, you get the jewelry, you get the gold coins. No. The first step is to file a petition with the probate court to open the process and to prove the will. Until this happens, no one is allowed to distribute or discard any property. After all, it is the probate court's role to verify that the will is legally valid. After all, someone might question the nature of the will. Happens all the time. Was it properly executed? Or was there another will that has been submitted at the same time? Sometimes there might be issues with some of the witness signatures, and that can present some problems. Also, are there accusations of undue influence or impaired mental capacity when the will was signed? Very important questions. Also, do you have a reasonable sense of all the assets and also a reasonable sense on who they are going to be left to? If you can pass all these tests, then you are likely in the clear. Step number two, I'm going to call this one send notices. If everything proceeds as usual, the straightforward probate case and it goes right through the court system, well then the probate court would usually approve the will and officially appoint an executor or an administrator. It is then the executor's job to notify any interested parties or creditors. So make a list. Make sure you do not leave anyone off of the list. In most states, the court will give you a list of people who will get notice. Give you an example. Say a man dies who is single but has 2 children, and he decides to leave his estate to his friends or acquaintances at work. It happens all the time. Well, not only do they receive a notice, but also the children would get a notice also. So it's very important that the executor or the administrator gets these notices sent out to the right people. Let's say you don't know the address of a particular person. Then you're required to post a notice in a local newspaper. Maybe someone else will come across that posting and alert that individual about the probate case. Who needs to receive the list? Well, the list can be rather long. I've made a short list that I think is fairly important. Any beneficiary that is named in the will. Fairly simple. Anybody who is in that will, you have an address form and that, send them a notice. What if there is no will? Well, any relative that would possibly inherit the estate or parts of the estate, probably send them a notice. Also, creditors. Can't forget about the creditors. Any creditor that you know, send them a notice. So when you're going through the financial documents or the bills, any kind of personal documents, write all those names and account numbers down and send them a letter. Let's say the will is uncontested. That would mean that everyone agrees that the will is valid and there is no objections and no one is going to challenge the will. Then the probate court has a fairly easy job to do. They then just need to review the paperwork and sign off on the paperwork. Sometimes it does not go so smoothly as that. Let's take, for instance, possibly someone feels there is a different version of the will, and they feel that that new will should be honored instead of the will that has been presented to the court. Well, this brings up all kinds of problems, and the judge will have to be much more involved. The more that the beneficiaries and potential heirs disagree about how to handle the estate, or if a will is valid or not, the more likely that the probate judge will need to weigh in on the case, possibly have the executor or the administrator provide more documentation. So earlier I mentioned about the father who left his inheritance to his friends instead of to his kids. Let's just say hypothetically the kids would like to challenge the instructions of the will, they probably would have to prove that someone exerted undue influence on their father, or that he lacks sufficient mental capacity. I also mentioned earlier about sending letters to creditors. Keep in mind that creditors have a limited amount of time to submit a claim for any kind of outstanding debts. So they do have a timeline that they also have to abide by. Step 3, take inventory. The executor or the personal representative also has a job of assessing the total value of the estate. This means determining the value of all assets. There can be many assets. Just to name a few, you could have real estate. Maybe it's a primary residence. Maybe it's a vacation home. Stocks and bonds and mutual funds. Jewelry, gold, silver. Maybe they were a collector of artwork. Cars, trucks, boats, motorhomes, camper trailers, tractors. There is a wide variety of lists that someone possibly could have owned. After all, inventory is very important to the probate court and to the heirs of the estate. Coming at number 4 on my list, we're going to call this one distribute the assets. Now that you have a good solid inventory, you know what is there, and you have approval from the probate court, you're ready to distribute the assets. Take a deep breath though, because sometimes carrying out the will's instructions can feel like a large task, especially if there are many heirs and assets to distribute. As an administrator for the estate, keep in mind you also have to pay the debts and taxes. Also, don't forget to submit for any kind of life insurance claims. And don't forget to pay any kind of outstanding medical bills. Also, retirement accounts. Make sure they get closed out. Things like IRAs, 401ks, company pension plans, etc. Step number 5 on my list. It's time to close out the estate. Yes, now that the assets have been sold, distributed, or thrown out, maybe somebody didn't want some items and you had to throw them out, and the court fees have been paid and the IRA accounts and the 401k accounts have been closed out. It is time to dissolve the estate and the probate process. Now remember that the probate case is a matter of public record, so legal records will be kept on file on your probate case. So in conclusion, if you enjoyed this video, please give it a thumbs up. If you do have any kind of questions, by all means, reach out to me. Glad to be of any assistance that I can. Until the next video, take care and stay safe.